Hi, I'm Freya Kodar. I am the Associate Dean Administration and Research at the Faculty of Law. And I grew up in Toronto on what I now know to be the traditional territory of the Haudenosaunee, the Métis, and most recently, the territory of the Mississaugas of the Credit River. So I am both a settler and a visitor to this territory. And I want to start by acknowledging that I am speaking to you from the University of Victoria, which stands on the traditional territory of the Lekwungen peoples. And I want to acknowledge the Songhees, the Esquimalt, and Wasanich peoples, whose historical relationships with the land continue to this day. I feel so privileged to work and play on this territory. And I encourage you to take a moment to acknowledge the territory on which you are on today. I'm delighted to introduce my colleagues John McLaren and Pooja Parmar, who are going to be speaking about their research on the Komagata Maru episode in their talk, Racism, Rights, and Empire in the Dominion of Canada, the case of the Komagata Maru. So John McLaren is an emeritus professor at the Faculty of Law. He is interested in both Canadian and comparative colonial legal history, and he has researched and written on legalized discrimination against racialized and ethnic minorities, especially Chinese immigrants and the Doukhobors. He's also written on the rule of law and on the British colonial judiciary. Most recently, with Dr. Parmar, he has been conducting research on BC lawyers in the early 20th century who represented unpopular causes, things like labor, Indian migrants, and suspected Bolsheviks. Dr. Parmar is an associate professor at the Faculty of Law. Her current research focuses on the legal profession, and she is involved in projects on the history of the profession in BC, as well as contemporary conceptions of ethical lawyering and professional responsibility in multi-juridical spaces like Canada. In her published research, she has examined aspects of oral history, legal pluralism and indigeneity, the role of lawyers as translators across legal worlds, and intersections of law and colonialism. Please join me in welcoming them both.
So in 1930, a would-be visitor from India to Canada, traveling from New York to Toronto by train, was detained at the border. When that person, the first woman to study law at a British university, and the famous Indian lawyer Cornelia Sorabji, tried to explain that as the holder of a British Empire passport, she should be allowed to enter Canada without a visa, the customs officer allegedly replied, "Canada is not in the British Empire." To explain this bizarre incident, we need to turn the clock back 16 years to the summer of 1914. In April 1914, a chartered vessel, the Komagata Maru, left Hong Kong with 376 mainly Sikh passengers to travel to British Columbia as would-be immigrants to Canada. And here's a picture of the ship in the Vancouver harbor. The charterer, Gurdit Singh, a businessman, was determined to test Canada's immigration laws and policies to immigration from the subcontinent. And here's a picture of him wearing the turban with the officials of the Komagata Maru. Beginning in 1907, in response to racist pressure from BC, its politicians at various levels, and a large segment of its white population, Canada sought to bar immigration from India. Ottawa employed Orders in Council and revisions to the Immigration Act to achieve this end. It did so more particularly, first, by the continuous journey order that required travel to Canada directly from one's country or place of birth without intermediate stops in order to land. And second, a discriminatory and exacting fee of $200 applicable to Asian immigrants from India. At the same time, Parliament sought to render the immigration process impervious to interference by the courts. In several instances, the BC Supreme Court had struck down various versions of these orders using the writ of habeas corpus. that required one detaining another to justify the detention at law. This allowed Indian migrants into Canada on the ground that the federal or provincial government had acted in excess or abuse of its stated powers under the British North America Act or under the Immigration Act in order to detain or deport them. The judicial response had encouraged Gurdat Singh to believe that with the court on his side, he and the other passengers would be admissible to Canada. By the time the Komagata Maru reached Vancouver, Ottawa had revised the orders to accord with the exact wording of the Immigration Act and added a third, barring all would-be migrants of the laboring class from entering Canada by any port in BC. Facing Gurdat Singh and his passengers was a resolute immigration office in Vancouver led by Malcolm Reid, closely influenced by the Tory MP for Vancouver, the racist H.H. Stevens. Both were committed by fair means or foul to prevent the Komagata Maru passengers from landing and the court from intervening. The result was a 2-month standoff in Vancouver Harbor from late May to July, as the Komagata Maru was effectively quarantined. During this time, very few of the passengers were allowed to land. Realistic contact with legal advisors was prevented. Lawyers of the department stage-managed a hearing by the BC Court of Appeal that upheld its view of the exclusionary effects of Canada's immigration laws. Threats of naval action were made, and after 2 months, the ship left and sailed back to India with most of its passengers aboard. This episode of Canadian history fits into the broader history of Canadian lawmakers' fervent desire to keep Canada white and free of Asian immigration. It is now well known through the work of community members and a number of scholars, and includes these books by scholars in BC. What we want to share today is some of our research about what the passengers expected from the Canadian legal system, the assumptions about law and justice they and those before them carried with them from one part of the British Empire to another, and their encounters with law and legality on Canada's west coast. We will set out the ideas about Canadian law and its potential or otherwise in furthering the object of Indian immigration to Canada. The starting point is that Indians, like Canadians, were British subjects within the British Empire. Unlike earlier migrations from British India in the form of indentured labor to various British possessions, the men who moved to BC from the Indian subcontinent financed their own travels and arrived voluntarily as free men. In addition to competing with white Chinese and Japanese immigrants for available jobs in the lumber industry, several were also able to buy land and other property and set up incorporated businesses over time. Within a few years of their arrival, they were also able to build places of worship and perform religious ceremonies, as well as provide social support to their community. So on the slide here is a picture of these early immigrants. So very little is known of the personal and individual aspirations or disappointments of the majority of the passengers on the Komagata Maru. Some pictures have survived, like this one, as have some biographical details, but not a lot more. However, broader historical accounts of the time suggest that just as in the case of first immigrants to arrive in BC from India in 1903 and 04, a range of reasons motivated them. Changes in land ownership patterns and property relations in British-administered Punjab in the late 19th century, as well as the increased recruitment of Punjabis in the British Army and to colonial police forces, led to movement of men out of Punjab. Indian immigrants to Canada were in search of new economic opportunities. Some were farmers and tradesmen from Punjab. Others were former Sikh soldiers and policemen who had served the British Crown in India, Singapore, Hong Kong, Shanghai, or in other British possessions in Asia, and who had already traveled outside Punjab for work opportunities. While the earlier wave of migrants was drawn by the economic opportunities advertised by Canadian steamship companies that were inviting labor to Canada and seeking to fill their vessels with incoming passengers, those on the Komagata Maru were influenced by both Singh and their countrymen already settled in Canada. These men carried with them particular ideas about law and judges. There were certainly questions raised about the legitimacy of colonial rule of law in India during this period, but at the same time, there were some on the subcontinent who came to view colonial courts as legitimate dispute resolution institutions that operated not only independent of traditional local hierarchies, but also served to limit the authority of local British administrators and business operators. So it's worth noting that to these men arriving from another part of the empire, neither the invocations of racial superiority by many white residents of BC, nor absence of legal equality between races would have been a surprise. Racial hierarchies were very much also part of life in British India, politically, legally, and socially. The racist environment in BC would have only provided further proof of the gap between the promise and practice of liberal ideals of equality and justice in the empire. However, at the same time, the growing use of English law and invocations of British justice by colonial judges in India, as well as by lawyers and other educated Indians to demand rights for Indians, and the resultant inclusion in the imperial legal order, despite barriers, was felt to entrench Indians' status as British subjects. This would inevitably have also shaped the expectations of the passengers. These ideas of British subjecthood and justice certainly appear to have played a role in the choices Gurdat Singh made. He had left his village in Punjab in 1885 at the age of 26 in search of economic opportunities and went on to establish successful businesses in Singapore and the Malay states over the next 3 decades. He was not new to litigation or to courts. His writings, as well as a number of historical and popular accounts about his life, journeys, and experiences, offer important insights into his assumptions and expectations about the possibility of Canadian law and legal processes to deliver justice. Imperial rhetoric and earlier practice relating to Indian migration would have further suggested to him and to the passengers that as subjects of empire, they were entitled to equal rights with other British subjects, including free mobility within Britain and its possessions. In fact, Queen Victoria had issued a proclamation in such terms to her Indian subjects in 1858. And as you can see, it states, "We hold ourselves bound to the natives of our Indian territories by the same obligations of duty which bind us to all our other subjects, and these obligations, by the blessing of Almighty God, we shall faithfully and conscientiously fulfill." This was interpreted by many from the subcontinent as a pledge of racial equality and a promise to observe perfect equality of mobility between her British and Indian subjects, not least by Mohandas Gandhi, who was at the time the tireless campaigner against discrimination towards Indian migrants to Britain's South African possessions. By the mid-19th century, in the wake of the abolition of slavery in the British Empire, a calculated and ostensibly well-regulated system of encouraging Indians to migrate to undertake indentured service in other British colonies was in place, lasting until the 1920s. To the extent that free migration existed, it was assumed that Indians were treated as British subjects whose rights of passage and residence extended at least to Britain itself. Although the numbers were not large, Indians were freely admitted to the United Kingdom during the 19th and early 20th centuries. Given these circumstances, it is hardly surprising that the average Indian at the time did not make a distinction between the governments of the UK, Canada, British India, or any other British colony in terms of honoring the Queen's promise. The expectations of law would have further been shaped by the apparent success of those who challenged the Immigration Department's negative determinations through habeas corpus and other proceedings before the courts in BC. So here are some cases that were decided between 1908 and 1913 by BC courts. The outcome in these cases appear to have certainly influenced Gurdit Singh's belief in colonial law and justice. He was convinced that if allowed before the BC Supreme Court to apply for a writ of habeas corpus, the court could be persuaded that the government had acted illegally if it denied the passengers entry. This attitude prevailed despite signs that the Canadian government was out to prevent any further landing by amending its exclusionary orders, and an early warning about the tenacity of the immigration officials in Vancouver by Bhagwan Singh Jack. Jack was a former teacher and a Granthi, or Sikh religious leader in BC, who had previously been illegally forced to board a ship leaving Victoria for Asia by the anti-immigrant immigration officer Malcolm Reed. So I'm going to turn it over to John now to talk about the Canadian legal realities of the time.
Canada, including BC, had, like India, received English law, including common law and the prerogative writs administered by the judges, and that included habeas corpus. However, as a consequence of the British North America Act of 1867, Canada, unlike India, had been granted by London a significant degree of self-government and wide control of what legislation it and its provinces enacted. London retained a residual power of disallowance of Dominion legislation that offended imperial legislation that was applicable throughout the empire, and in theory that was repugnant to the values and principles of English law. In Canada, individual and group rights and protections were in both theory and practice thought to be the product of local legislation, except where received as part of English law. By the same token, it was accepted that these received rights and protections could be limited or even expunged by local legislation in certain circumstances, for example, in perceived emergencies. By the process of constitutional interpretation applied to the British North America Act by the Judicial Committee of the Privy Council, the highest appellate body in the empire, the legitimate task of the courts was to determine which level of government had jurisdiction over the matter in question, not to evaluate the quality of the legislation in dispute. This was so even if it discriminated on the basis of race, for example, in the denial of the franchise to a naturalized Canadian of Japanese heritage that happened in the case of Cunningham and Tommy Homer. In British Columbia, the Supreme Court justices believed that they possessed the power to issue writs of habeas corpus to those who claimed that they had been wrongfully imprisoned or detained by the government or its agents, typically because the authority had acted outside or in abuse of its powers. The Supreme Court had shown itself in several cases involving denial of entry to or potential deportation of immigrants from India, ready to call out the Immigration Department for exceeding or abusing its legislative powers. The effect was to allow the applicant's entry or the right to stay. One advantage of habeas corpus was that if denied by one judge of the Supreme Court, application could then be made to another, and so serially. There was, moreover, in British Columbia, no regular appeal when a judge issued a writ of habeas corpus. In one instance previous to the Komagata Maru episode, the case of a sister vessel, the Parmar Maru, in 1913, the judge, Chief Justice Hunter, while granting the writ because of abuse of process by the department and allowing 38 passengers to land, indicated that the court had no power to evaluate the quality of the exclusionary legislation, as counsel for the migrants had pressed on him in an alternative argument in this action. But it was not only Canada and the would-be migrants that we should be interested in. There's also the question of the position of the government in London, the imperial government, and Pooja is going to deal with that.
By dawn of the 20th century, the white self-governing dominions had begun to crystallize the exclusionary instinct in law and policy, clearly designed to screen out migrants of color, although not always by name. For example, Australia and New Zealand legislated the notorious language test borrowed from the Southern African colony of Natal that demanded immigrants, largely from India, be tested in a language of Europe. By contrast, Canada's commercial and diplomatic interest in East Asia had seemed to demand more subtlety. Thus, although reducing the number of Chinese immigrants was sought openly by legislative means through a head tax, limiting the number of Japanese migrants allowed into Canada was achieved by a diplomatic accord with reliance on controls by Japanese local authorities. Further, repeated attempts by the BC legislature to enact its own version of the Natal Act were in most instances disallowed in Ottawa, or in one instance declared unconstitutional by the BC Supreme Court. This did not, however, mean that Canada was open to immigrants from India, as the continuous journey, discriminatory land fee, and exclusion of laborers' orders demonstrate. Canada's approach was as palatable to London as the language test. The imperial government, sensitive to settler sentiments in self-governing dominions, as well as to fears raised by the government of India about internal unrest related to discrimination against its subjects elsewhere in the empire, had decided to play both sides of the street. The underlying policy had been floated by none other than the British Secretary of State for the Colonies, Joseph Chamberlain, in 1897. In his address at the Colonial Conference of the Self-Governing Colonies of the British Empire, he emphasized that immigration of the undesirable kind must be prevented. And as you can see in this extract from his speech, he says, "We shall not offer any opposition to the proposals intended with that object, but we ask that you also bear in mind the traditions of the empire, which makes no distinction in favor of or against race and color, and to exclude by reason of their color or by the reason of their race all Her Majesty's Indian subjects." The reality was that imperial commitments to free migration was rhetorical, and Britain basically stood by as exclusion was implemented by the white dominions, including Canada. By the time the Komagata Maru sailed into Vancouver Harbor, one other development had begun to worry governments in London, New Delhi, and Ottawa. This was the increasing support for the anti-imperialist Ghadar Party in North America. The expat organizers were committed to the independence of India by revolution, if necessary. Members or supporters of this movement were believed by these governments to be present among the Punjabi immigrants in BC, not least among the leaders. I'm going to turn it over to John now to speak about the legal denouement in June and July of 1914.
So I'm going to talk about the various parties involved in this legal dispute and those who represented those parties. On the one side stood Gurdit Singh, the Passengers and the Shore Committee, comprising leaders of the local Indian community, who were committed to testing Canada's exclusionary immigration policies and legislation towards British subjects from India. And here is a slide of a group of passengers with Gurdit Singh and his young son. They were hoping that either the light of imperial benevolence represented in the 1858 proclamation and the merit of their cause would shine through, or that through the use of the writ of habeas corpus, the judges would come to their aid and that they would be landed. On the other stood the Department of Immigration, represented by Chief Officer Malcolm Reed, echoing his master H.H. Stevens' voice, and assisted by a former Calcutta police officer, William Hopkinson, who had turned spy master and informer. And on this slide, between the two men from the press, you can see Reed, Stevens, and Hopkinson. The office was committed at all costs to prevent the passengers from landing and from seeking the assistance of the Supreme Court through the writ of habeas corpus. The object was to persuade the would-be migrants to turn round and head back to Asia. Their exclusionary stand would be supported by lawyers in Vancouver, retained by the department to protect its interests. Seeking to represent Gurdit Singh and the passengers was the solicitor for the Vancouver Khalsa Diwan Society and Sikh Temple, members of which had formed the Shore Committee to assist the passengers to land. His name, and here you have his photograph, was J. Edward Bird, well known for his representation of labour interests, a member of the Socialist Party of Canada, and as one not afraid to call the authorities to account in his advocacy. Malcolm Reed and his men, blessed with a discretionary administrative system of immigrant assessment, did everything in their power to prevent the bulk of the passengers from accessing the courts. Supplies, especially foodstuffs, were denied to the sequestered passengers to induce them and the Japanese captain and crew to weigh anchor and leave. When that stratagem did not work, an abortive attempt was made to storm the vessel with armed police, an attack that was repelled by the passengers from above. Bird was not allowed aboard the Komagata Maru to consult in confidence with his clients, only to talk on one occasion to Gurdit Singh from different vessels over a watery gap at all times in the hearing of department officials. The lawyer, supported by the Shore Committee, pressed the local office to start processing the passengers through the system. That would have allowed him to take a test case on habeas corpus to the Supreme Court. The most Malcolm Reed would do was to process those who would be sure to be rejected because of negative medical exams, clearly on his part a delaying tactic. As time wore on, the Komagata Maru remained in harbour. Reed's efforts to induce the vessel to leave spluttered, but most of the passengers remained aboard, unable to land. Bird, supported by the Shore Committee, but not entirely by Gurdit Singh, agreed with the department's lawyers to initiate a test case with a passenger of his choosing. This person would be denied entry by the Immigration Board, proceed to apply for a writ of habeas corpus that the judge would reject. This was to enable the case to be sent forward to the BC Court of Appeal as a test case for its opinion on whether the decision to bar entry to the passengers on the Komagata Maru was justified as a matter of law. Bird chose as the subject of the proceedings Munshi Singh, a young farmer from Hoshiarpur in the Punjab who had left his wife and a daughter there while he set up a new life in Canada for them all, with farming as his objective. Munshi Singh had arrived with far less than the required $200 for landing in his possession. The scripted process quickly played out. Singh was denied entry by the board as not having come by a continuous journey, lacking the $200 entry fee, and being in the excluded class of a, quote, labourer, unquote. The writ application was rejected by Justice Murphy of the Supreme Court, and the case was forwarded to the British Columbia Court of Appeal. Now, in only what can be described as a precipitate process, Bird and his co-counsel, Robert Cassidy, King's Counsel, were given 2 days to prepare their case for presentation to the full court. Two other senior counsel had interestingly refused Byrd's invitation to work with him on this case, viewing the issue as a political and not a legal one. During argument by Cassidy that the orders in council on continuous journey and the landing fee did not or could not have an exclusionary effect, and that the board had misapplied the labourer directive, it was clear that the judges were not sympathetic and were impatient with further argument along these lines. Byrd, with a rushed argument based on traditional British notions of the rule of law, and then Cassidy, with a more considered one, sought to argue that the term British subject had legal meaning in Canadian law. It provided protection, he suggested, from the attempt to refuse entry to those subjects from India under Dominion immigration legislation. Although invoking the Immigration Act was legitimate as a means of controlling entry by aliens, it did not extend to British subjects who had a right of free movement and a right to enter any other British possession. On the issue of constitutional authority, Cassidy argued that as the Komagata Maru in Vancouver Harbour was within provincial jurisdiction, the treatment of its passengers interfered with their civil rights and was thus beyond the powers of the Dominion authority. Lawyers for the department argued simply that under the British North America Act, the Dominion Parliament had jurisdiction over immigration. Furthermore, it applied to British subjects as well as aliens. Constitutionally, once jurisdiction was established, it was no objection that a legislative provision discriminated between classes of people, even on the basis of race. The 5 judges of the Court of Appeal in separate judgments essentially agreed with the arguments for the department. Said the court, the Dominion authorities had acted in tune with the legislative authority over immigration granted to them under the British North America Act, and that extended to British subjects as well as aliens. According, their actions taken were within their power and authority. Moreover, the Dominion Parliament had occupied the immigration field, and there was no question of a clash with provincial jurisdiction over civil rights. Several judges went further. Justice Archer Martin noted that within Canada, subjects were treated differentially by the law for some purposes, and he gave as his example Indigenous people. Justice Gallagher described as fanciful the idea of an imperial jurisdiction in which everyone enjoyed equal rights, including mobility. But Justice McPhillips went as far as to justify the substance of the exclusionary regime in Canada against those from India. He asserted that it accorded with racial and cultural divisions in the world. Moreover, it satisfied the need to protect Canadian society and culture from people whose social norms and cultural practices were communal, family-centric, superstitious, and generally cruder than that of white Canadians. Of significance, too, was a decision recently handed down by the Supreme Court in the case of Kwong Wing versus the King. This decision affirmed that it was not open to a court in Canada to assess the quality of legislation that was claimed to be discriminatory on racial grounds, as long as it fell within the constitutional jurisdiction of the level of government that claimed it. In this case, Saskatchewan legislation banned Chinese restaurateurs from hiring white women servers. The Supreme Court of Canada upheld this legislation on the ground that it fell within provincial jurisdiction over labour and public health. With this decision in their favour, the local immigration authorities increased the pressure on Gurdeep Singh and the passengers to leave, including the threat of armed naval action. With the direct intervention of the Dominion government and the supplying of the Komagata Maru for a return voyage, the ship left harbour on July the 24th to return to Asia. And there is a picture of the ship steaming out from Vancouver. Now, what lessons about law and its reach and racism in both Canada and the British Empire do we learn from this story? If Gurjit Singh thought that either a broad, widely understood conception of imperial citizenship had purchase in the British Empire, or that the vaunted institutions and principles of British justice would provide protection against racism and freedom of movement for non-whites in Canada, he had his answer. Throughout this episode, and in the decision of the British Columbia Court of Appeal, the following were all exposed. The limited nature and weakness of traditional protections of English and Canadian law for the rights of individual groups. The bloodless constitutional interpretation of the British North America Act by both Imperial and Canadian courts that ignored and implicitly condoned legislative or administrative racism. And the opposition of Canadian legislative bodies to considering, let alone providing, actionable political, economic, social, and cultural rights for minorities. Canada had in fact joined Australia, New Zealand, and South Africa as definitively constructing two conceptions of empire. One of white British subjects welcome as citizens, the other of British subjects of colour who were definitely not welcome. This helps explain the view of the immigration officer at the US-Canadian border in 1930, who said Canada is not in the British Empire when challenged to admit Cornelia Sorabji, an Indian subject of empire. Canada was not to purge itself of its White Canada policy for a further 3.5 decades, nor of its aversion to treating at law non-white immigrants as full human beings. A small Indian migrant community remained in Canada, showing courage, resilience, and enterprise in the face of widespread discrimination by, or at the best, calculated indifference of white Canadians. The imperial government had shown itself again thoroughly spineless in the face of the destructive racism of the self-governing dominions. Its proxy in India, the government of the Raj, as always fearful of challenge, and worse still mutiny by the colonized, had by August 1914 and the outbreak of war converted the passengers on the Komagata Maru from would-be migrants, and the Sikhs in particular as loyal subjects of empire, into troublemakers, and worse still, into seditionists. In this they were influenced by propaganda about the Komagata Maru by Canadian government sources. This helps to explain their insensitive treatment as suspects on their return to India. British India remained largely loyal to the empire during World War I, providing a large part of the active military forces deployed, some of whom in fact on the Western Front fought alongside Canadian troops. However, the empire in India was in trouble. The memory of the Komagata Maru episode and what it stood for in imperial policy, the dithering of the imperial government and the contradictions in its policies on pressure for greater autonomy in the wake of World War I, various campaigns for freedom in reaction to British perfidy in its policies, and the naked use of violence against unarmed Indians in the Amritsar massacre of 1919, all proved to be steps in the road to strengthening demands for Indian independence from Britain and the rejection of imperial links. The victory of racism in this story, as well in other dominions, took decades to correct. Even today, as the incidents of hatred against Asian Canadians, as well as widespread systematic racism show, the long shadow of racial superiority and rank colonialism, evident in the Komagata Maru episode, continue to haunt us. We thank you very much for joining Pooja and myself in this presentation, which has allowed us to talk about the importance of law as part of this story and how the law was variously interpreted, but which in the final analysis all led to the greater embedding of racism, not only within the British Empire but more specifically within Canada.